So today we're going to talk about this big development out of the Sandy Hook lawsuit against Remington. There's a big settlement that just came down where the families of the victims are going to be awarded $73 million by Remington, or really by Remington's insurers, because Remington went bankrupt during this whole process, and all their assets and operations got sold off. And what was left for this case were the insurance policies that the former company had held, and so the insurers were ultimately the ones who made this decision to settle with the group. But I want to get your just general overview of what happened here. How do we get to this point where a major gun company, or at least the remnants of one, are paying the victims of a mass shooting that they weren't, obviously Remington wasn't directly involved in. It was a Bushmaster rifle, which Remington owned at the time, was used in the shooting. But how do we get to this point where they're being held responsible for what happened?
Yeah, well, and first of all, I don't know that it's actually, I haven't seen the details of the settlement, but I would be shocked if the insurers actually admitted liability on behalf of ROC. So I don't know that it's fair to say that they're being held responsible. Certainly that's how it's framed, and I think that's going to be the takeaway, from most people who see the headlines here. But like the Associated Press in its first report, they said this was the first time that a gunmaker's been held liable for a mass shooting. They deleted that from subsequent reports. But by that point, I've seen multiple blogs and sort of news aggregator sites that have falsely put that out there. So, my first takeaway is that gun control groups got to win here. We can talk about the fact that this was insurers settling and not Remington itself, that no liability was admitted, but the headlines and the takeaway is that a gun company was held responsible for Sandy Hook, whether that's right or wrong, legally speaking. How we got here, I think, honestly, Stephen, how we got here was through, I think, a very sympathetic court. We've got the Protection of Lawful Commerce in Arms Act. It's been on the books since 2005. It's a federal law that is designed to prevent gun makers from being sued for the criminal misuse of their products, right? And that's the gist of it. But the Connecticut State Supreme Court, in a 4-3 decision, said that these families could pursue claims against Remington on one count only, for violating Connecticut's Fair Trade Practices Act. So basically, they went after Remington for the marketing. And the State Supreme Court said at the time, look, it's going to be a pretty, I think Herculean was the word that they used, a Herculean task to prove that the killer in Newtown, Connecticut, was there's a causal relationship between the advertising by Bushmaster and the fact that this guy decided to murder a classroom full of first graders, as well as killing his mom, as well as killing teachers and staff in that school, and that he specifically chose to use the gun that he stole from his dead mom because of the advertising by Bushmaster. And I agree. I think that was a Herculean task. And I think it's why a lot of people really were, within the industry and within the 2A community, not just surprised, but shocked and disappointed that all of a sudden we got news of the settlement. Knowing that it was the insurers that decided to settle these claims, I think makes it a little bit more understandable. But I would have liked to have seen this case gone to trial, because I think it would have been very difficult to prove. Everybody's sympathy goes out to these family members who are living and will continue to live with the pain of that awful day for the rest of their lives. But I do think that it was inappropriate to say that Remington was to blame because of their advertising that we don't even know if the killer was even aware of. And so that, I think, ultimately is how we got here. Now, why the insurance companies decided to settle, I guess we'd have to ask the insurers, but basically they paid out what they figured the full value of those claims would be. And so maybe it was a monetary decision. But one of the curious things about this settlement is that apparently, as part of the settlement, the insurers agreed that a lot of documents that the families had already obtained from Remington, or the remnants of Remington, could be released, but that basically the fishing expedition would stop. They're not going to get any more documents. And so I do wonder. I don't think there was anything particularly damning. I don't think there was an email out there from a Remington executive saying, "Hey, what if we market this gun to unstable young men?" I don't think that there's, a quote unquote smoking gun, no pun intended, email like that. But I do wonder if that played any role in the decision to settle. I honestly, I don't know. I can't imagine that the insurers would have a vested interest in the documents of a company that really no longer exists. But again, there are, I think, some continued questions about the settlement and why it actually took place.
Yeah, I think there's a lot of continued questions. I mean, I share some of your surprise. I will say that obviously, in hindsight, it seems like this was going to be the outcome after the Supreme Court declined to intervene, the United States Supreme Court. Because after the Connecticut Supreme Court made their decision, Remington appealed it to the U.S. Supreme Court, which didn't take the case. It didn't offer an explanation for why it didn't take the case, but it didn't. And it seems the trajectory from there was a couple months after the Supreme Court declined, Remington went into bankruptcy, probably in part because of this lawsuit, although not entirely because of it, I would imagine. We can talk about that a little more in a minute. But and then after that, when the insurers were the ones left, after all the assets of Remington were sold off, because this is a confusing thing, I think, for a lot of people, right? Remington still exists, or the brand still exists.
Right.
You can still buy Remington ammunition. You can buy Remington-made guns. A lot of those operations are actually coming back online now that they've been sold off to other companies. It's just that the Remington as an ongoing independent company doesn't exist anymore because it went bankrupt in 2020. And it was already struggling before that. It had gone into bankruptcy in 2018. There were a lot of issues that we can get into later beyond this lawsuit, but certainly a big one was this lawsuit. Then after the assets were sold off, the insurers effectively took over control of this lawsuit because all it remained were their insurance policies that were valued up to $73 million. And it only took them a couple months to try and start settling this case. They first offered like $30 million,
Right.
which the plaintiffs rejected. And then only a few months after that, they basically gave in to the full amount of their coverage, which is where we're at. That's what happened this week. And so the timeline there is fairly clear, I think, as the Supreme Court, it's a combination of the Connecticut Supreme Court's ruling and then the United States Supreme Court refusing to intervene at that point led to this path. But there are, like you said, it's still a lot of things that just, it's hard to understand why the insurers thought this was the best course of action. And I do want to drill down for a moment on what you mentioned in terms of how this has been reported and what's important to note, right? This was not a court ruling or a jury's decision. This was a settlement between the plaintiffs in this case and the defendants, which effectively became the insurers of Remington after it went bankrupt. And so it doesn't set any legal precedent. There's nothing directly impacting the Protection of Lawful Commerce in Arms Act, which is the federal liability protections for gun makers and dealers that was designed in the 90s to counteract exactly these kinds of lawsuits. Because this suit's not a new tactic.
Right.
It's a new strategy. They've come up with a way that they believe they can get around the PLCAA because PLCAA, one of the exceptions is if you've broken a state law, then the PLCAA liability protections don't apply in that circumstance. And so the argument here goes that Remington, or really its subsidiary Bushmaster, broke Connecticut's advertising laws because its advertising was too aggressive. There was one of the ones they pointed to was consider your man card reissued with a picture of the rifle. That was a big centerpiece of this case. And then also The rifle was featured in a video game, Medal of Honor, which was popular years ago, but it's similar to Call of Duty. People know that franchise.
You're making me feel old by trying to explain the Medal of Honor franchise, by the way, Steve.
Yeah, Medal of Honor, they haven't made that game in quite a long time now. But back in 2012, that it was obviously it was sort of the last legs of the franchise. And they had a game where it featured, most video games feature fake names for the guns. And I guess this lawsuit is probably part of the reason for that, because Medal of Honor featured the real names of actual guns in the video game. And that was, so there's a violent video game aspect of this case where they're arguing that because Remington put its guns in this video game, put the names of them, that contributed to that this was illegal, unfair business practice under Connecticut law. Honestly, the whole thing is a little bit hard to even get your head around, because obviously these they're advertising this was directed at people who could legally purchase these guns, and then you have on the other hand,
this is why I think
the facts of the case is he didn't buy the gun anyway. As you noted, there's no.
And I think that's why it gets back to the state Supreme Court saying it was going to be a Herculean task to actually prove these allegations, because you're right. I mean, first of all, think about how many people played the Medal of Honor franchise. How many millions of people there were who played that franchise. It seems to be like, blaming Sandy Hook on a video game is kind of like, blaming a crime on an Ozzy Osbourne album back in the 1980s, or, Judas Priest made me do it. It doesn't resonate. I mean, if video games were the proximate cause of this, shooting, frankly, we would see a lot more of that, because these video games are incredibly popular. We're dealing with a terribly damaged individual here. And again, there were all kinds of warning signs. There were failures on the part of his own mom to actually, get him the treatment that was needed. But again, that none of that really mattered to the argument that the families were making, or the attorneys for the families were making, which, as you say, was that, these advertisements or this video game placement violated the Fair Trade Practices Act in Connecticut. And I don't know if you've looked at that law, Steve, but, they list everything from like arborists to zookeepers. Basically, they've got their list of regulations. Firearms is not in there. They don't have a specific category for firearms advertising. They have it for alcohol. They don't have it for guns, though. And so, again, I mean, I think it speaks to the challenge that the plaintiffs would have had to demonstrate conclusively that, that these advertisers was a proximate cause of this tragedy. On the other hand, I think that one of the concerns for the insurers may have been people want to hold someone accountable for this crime, and they can't hold the killer accountable, can't hold his mom accountable. So will they hold, Remington Outdoor Company or the insurers of Remington Outdoor Company responsible, because they're the ones that are there? And if you get this case in front of a sympathetic jury, I firmly believe that the Connecticut State Supreme Court allowed this case to go forward on this one claim precisely because they didn't want to be the body that said, no, you can't sue. You can't try to find some sort of relief or justice. I think that the sympathies of the court were with this family, which allowed this lawsuit to proceed. And I think one of the genuine concerns was probably that there'd be a sympathetic jury as well. So, on the merits of this case, I don't think that the plaintiff's attorneys had a really strong case at all. But I don't think that might have, at the end of the day, that might not have been the most important factor or consideration.